All right. Welcome to the first meeting of the Senate Judiciary Committee for this year's session. Today, we will be hearing bills, old friends. These are all committee bills. So if you tracked with us over the interim, you'll be familiar with these bills. If you didn't, that's fine. We're going to go through them. Still make sure that we understand what they're doing and that they're doing what we intended them to do. And with that, we'll go ahead and call the roll.
Senator Kriegel,
Here.
Senator Crum,
Here.
Senator Hicks,
Excused.
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
All right, thank you. Okay, committee, so the first bill that we have for our consideration is Senate File 7. This is theft amendments. This bill, as you'll recall, amends the penalties for theft, specifically and other related offenses. And then it amends the number of theft offenses required before the felony kicks in. So the bill, meat of the bill is on page 2. Romanette 3, misdemeanor was punishable by up to 6 months. Now it's up to a year. And a fine was $750. Now it's up to $1,500 or both, as long as the value of the property is less than $1,000. And then instead of having the 5th offense constitute a felony, we've elected to make it a 3rd offense. Misdemeanor will get you to a felony. And then what is 63411? Oh, same thing, amends it from 6 months to 1 year and $750 to $1,500. And this bill is effective on July 1st, 2026. All right. Do we have public testimony on this bill? We'll hear from any and all. Sure, the whole room. Who knew this was such a popular bill? We'll just start over on my left with Mr. Mosier.
Thank you, Mr. Chairman, members of the committee. Mike Mosier, Wyoming State Liquor Association. I won't be redundant on the testimony you had to endure through of mine during the interim. However, just that being said, we support this bill. Retail theft is obviously a major issue to our industry, partially because we sell products that are easily resold. We find that multiple offenses are common, and the crimes have gotten so bad that in some places, a convenience store, for example, had to close down just because retail theft was such a problem. And so,
Where was that?
in the middle of the state near a reservation, without naming names. And so you're finding more and more places. I mean, the liquor industry is struggling just because of decreased sales. And so this is just adding fuel to the fire. So we find this being similar to multiple DUIs resulting in felonies. I think the big thing to remember about this is the deterrent factor, because bad guys know how many misdemeanors it makes to make a felony. And so going from 5 to 3, which is the most important part for us in the bill, Romanette J, would be a great step. I think it's a matter of survival for some of us, our small businesses. And I will take questions. However, I do have another bill in committee, so just to toss in the next bill, House Bill 8, we do support because it gives law enforcement an additional tool for the same reasons I just described. Thank you.
Great. Any questions for Mr. Mosier? All right, thank you.
Good afternoon, Chairman Olson and members of the committee. My name is Amber Leba, and I am the COO of the Greater Cheyenne Chamber of Commerce, and I'm also here representing the Wyoming Retail Association. And just for time's sake, I was just going to include Senate File 7 and 8. So we stand in strong support of Senate Files 7 and 8. These bills provide much-needed tools to deter theft, close repeat offender loopholes, and ensure individuals cannot evade accountability by crossing jurisdictions. Wyoming realtors Wyoming realtors continue to face growing losses and safety concerns, and these measures would help protect businesses, employees, and customers while strengthening our economic environment. We respectfully urge your aye vote on both bills, and I will stand for any questions.
Any questions for Ms. Leba? All right, thank you.
Mr. Chairman, members of the committee, my name is Michael Smith, Wyoming State Director for NFIB, the National Federation of Independent Business. NFIB is the largest small business advocacy organization in Wyoming, representing small businesses in all types of industries, from auto repair shops to mom and pop retailers. I'm here today in strong support of Senate File 7 that will increase penalties for retail theft of Wyoming small businesses. Small business is the foundation of the Wyoming economy. Theft, including organized retail theft, continues to only become a greater challenge for our members to operate and have a successful business. Nearly all small businesses are victims of theft, and as small businesses operate on small margins, the costs have an impact on the bottom line. And theft not only drives up costs for small businesses, but also for all law-abiding Wyomingites. Stronger penalties will help deter theft and strongly penalize those who are not law-abiding, and unfortunately, will not be deterred by stronger enforcement on the books. We applaud this effort to increase penalties for theft of Wyoming small businesses. Thank you for allowing me to testify, and I urge your support for Senate File 7.
Thank you, Mr. Smith. Any questions, committee? All right, appreciate you. Ma'am?
Association. Our president, Loretta Hawkins, wanted to be here, but she was going to be here and then she couldn't be here. So I'm closer. The association has discussed this bill and also the next one. We support both strongly, and trust me, you've heard comments about people knowing exactly how many misdemeanors they have and whether they're going to pay any attention at all until it's number 5. And the answer is they don't. So reducing the number, increasing the penalty is one more tool in our toolkit. And we strongly urge you to pass both Senate File 7 and then, for similar reasons, Senate File 8. Thank you.
Thank you, Ms. Hackle. Any questions? You guys had too much to eat for lunch? Still in the coma?
Zero a lot, Mr. Chairman.
All right. Thank you, Ms. Hackle. Go ahead.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And our membership are voice support for this concept of the theft penalty changes and the reduction from 5 to 3. And like the testimony that you've heard this morning, the majority of our agencies in the state of Wyoming do serve the small communities. And while this discussion, I think, started trying to rein in the kind of the out-of-state theft rings and people that are coming to Wyoming to prey on us, I think this does have an impact for both. In our experience of roadside law enforcement, people that are in the business of stealing for stealing do know what the penalties are. They do research that, and they determine their actions based on the risk associated with that. And by increasing that risk, I do believe is a deterrent. And I'd be happy to answer any questions if you have any, sir.
Do we have any idea how many more offenders we will capture by in the system with the felony when lowering it from 5 to 3?
So, Mr. Chairman, if you're asking if more people will become felons as opposed to,
Well, I assume
No.
more will. Yeah. I'm asking. Yeah. Like, do you have any idea how many felons are created under the existing law? That would, I guess, give me some idea of what it could look like.
Yes, Mr. Chairman, I'm not familiar with the application of that across the state. So you have still have officer discretion at the scene to charge it as a misdemeanor, even if it would qualify as a 5th offense. And the prosecution has the discretion to prosecute 5th, 6th, 10th offense as a misdemeanor. So I think that opportunity to look at those on case-by-case basis still allows that best application of the law and yet be able to have this deterrent available, but I do not have specific numbers for you, Mr. Chairman, about the prosecution across the state of Wyoming.
Ms. Hackle, how difficult would it be for your association to at least ballpark that for us? You'd have to ask every single county prosecutor, wouldn't you?
We would, Mr. Chairman, members of the committee. What we could do is send out a group email and say, hey, can you let us know? Now, I can't tell you what, the response will be. Will we hear from all 23 county and prosecuting attorneys? Probably not. We'd probably hear from about half of them, but that might give you a fairly good idea. I can't tell you a number from my office, but an awful lot of people seem to me to fall in the 4 or 5 thefts range. And having the threat of a penalty hanging over their head often makes the individual somewhat more interested in resolving the case quickly, and that saves the system time and money on a felony trial. But I'd be happy to go back and have that email sent out and ask for an immediate response.
Yeah, I think that would be really helpful. I'm just trying to anticipate some questions that we might get as this bill moves along through the process. And anytime we're dealing with felonies, it seems to perk up certain people in the legislature's interest. And so if we had some type of tool that we could respond to, that would be great.
I will see what information I can gather. And if I might, Mr. Chairman, let me tell you that sometimes this isn't just shoplifting or theft. There is a case we are currently prosecuting in Laramie County that began as the theft of a hairbrush from Walmart. The theft or the hairbrush was recovered. The person who stole it is now dead because he was shot later in the evening. And it was related in the sense that we believe the perpetrator of the shooting wanted to become involved in stopping the shoplifting. So the more we can do to shut down retail theft, I think it's a good idea. So I'll see what I can find and I will let you know.
Excellent. Thank you. Any questions, committee? Yes, Senator Cole, go ahead.
Yeah, thank you, Mr. Chairman. And to that end about that information, I think the other side of it is what you just explained. Something was consequential happened because of that action. But do you feel that those folks would have got, like, say it's 5 and now we say it lowers to 3? Will it effectively change anything? I mean, at the end of the day, the things you talked about, the consequence for going to 3, it will be like the consequence going to 5. But your opinion about the overall, and I realize it's an opinion at this point, but just what your general sense is about what that means as a prosecutor with the experience you have. Overall, do you think it really changed? It helps to do this instead of hindering you to do what you've currently been doing?
Mr. Chairman,
Tackle.
Senator Kolb, at the risk of sounding like a cynic, no, I'm not sure it will. With the exception, even with death penalty cases, I've not in my career, which has spanned maybe more years than some of you have been alive, present company excluded, maybe, I don't know. But I have not found that the deterrent effect often impacts the individual. I don't think I've ever heard a defendant say, I was going to do X, but I knew the penalty was Y. So I don't want to undercut the bill because it is a useful law enforcement tool and prosecutorial tool. But I also have dealt with enough defendants in enough capacities throughout my career to know that if forward thinking and rational thought were a strong point, we wouldn't probably have as many problems as we do. And that's as honest as I can be.
Yeah, I think Senator Kolb's question really hits on the point of the questions around the felony. I think with the misdemeanor versus felony threshold, I can see that having a pretty big deterrence because as I understand it, there's testimony that offenders actually know the value that they can steal up to and keep them within the realm of the misdemeanor. And so I see the expansion of that capturing a lot more people, although they'll probably just figure out the new number and then we'll be back to the same game that we're at right now. And so to me, the most effective tool, honestly, in this bill is the reduction of the offenses to 3. So I would hope it would serve as a deterrence. Otherwise, our work would be in vain. But I agree with you. Better to have tools, prosecutorial and law enforcement tools in the tool belt. So thank you.
Welcome.
Anything else from anyone? Any response to anything that we've said or asked? Mr. Thompson?
Mr. Chairman, as we visit about the deterrence factor, there's also a portion of that is the prevention factor. So if we do have someone on their 3rd, 4th, 10th offense, they're going to be out of circulation for a time, preventing that continued theft. So I think it does twofold. It serves as a message, but if people don't get the message, they will learn the message eventually. And both, I think, benefit not only the retail industry, but the community and the residual crimes that accompany this. Because we hear testimony about the up to and including homicide. Theft oftentimes feeds a drug addiction, drug sale organization, and many other crimes are associated with it. So I do just think that all factors of this bill are things that could have a positive impact on the law-abiding citizens of Wyoming.
Do you think the punishment for the felony up to 10 years or $10,000 fine is still appropriate as we lower that down to a 3rd offense? Do you feel like that's still appropriate?
Yeah, Mr. Chairman, I mean, I think that's a question for those that make the judgment, but in my experience, I don't see someone that has their 3rd offense of stealing things worth $1,100 spending 10 years in prison. I think our judiciary and our prosecution recommendations are based on the facts and circumstances of those individual crimes. And but the question would be, if it's the 10th offense, does that person need to be spending 4 to 8 in the state penitentiary? Maybe that is appropriate.
Great. Thank you. Any other public testimony? Seeing none, I will close public testimony on Senate File 7. Committee, what is your pleasure?
Move the bill.
Second. It has been moved and seconded. Are there any amendments to this bill? Any discussion on this bill? Go ahead, Senator Kolb.
Yeah, thank you, Mr. Chairman. I think when we leave this to the deference of the courts and they'll decide, even though they could make that decision about how stiff of a penalty they think is appropriate. I think it gives them the latitude to make that decision when they know more than obviously we do right now. And I think that's good to have this. And I think it's also good to move a bill like this forward because it deals with a real escalating problem. And if we have to do something to try to say that, frankly, Wyoming's not that kind of a state that allows this to happen. That's why I'm in favor of a bill like this in front of us. Thank you, Mr. Chairman.
Any other comments? All right. Pierre, will you please do a roll call vote on Senate File 7?
This is a roll call vote on Senate File 7. Senator Craigo,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Excused.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right. Next bill for our consideration is Senate File 8, absconding for criminal purposes, criminal offense. We did get a little testimony on this, but just to remind everyone about what this bill is doing. It creates a new offense called absconding for criminal purposes. A person is guilty of that offense if they travel across a county line in Wyoming or from a county line in Wyoming, any county, to any outside jurisdiction outside of Wyoming, and do one of the 3 things. After having committed any criminal offense under the title, or with the intent to commit an additional criminal offense under this title, or to dispose of or conceal the proceeds or property or other items of value obtained after committing any criminal offense under this title, or in furtherance of any felony. Sorry, I said 3. There's 4 options. The penalty for absconding for criminal purposes shall be the same penalty for the most serious crime that was committed, was intended to be committed, or furthered as a result of the absconsion. And this bill is effective July 1st, 2026. All right. Public testimony that I know we heard from a few of you. Additional public testimony on this Senate file? Mr. Thompson?
Thank you, Mr. Chairman. Alan Thompson with WASCOP. We provide a lot of testimony and input on this throughout the interim. So I won't belabor the points, but I just think that this is another tool that can help law enforcement in those difficult situations where jurisdictional questions come into play. And that involves, from the municipal line to the county line to the state line. And I think this is a tool that also offers that discretion. It doesn't need to be charged if we have a straightforward case and we get our hands on the evidence and we get our hands on the person and we get them to face the charges in jail. But when crimes occur at 2:00 in the morning and judges aren't available and things like that, this just helps with another tool that we can transfer probable cause to another entity. They can hold on these. We can get cooperation from out-of-state law enforcement, maybe even federal law enforcement. And the concept itself is not unheard of on the federal level. We have the process of the UFAP warrant, unlawful flight to avoid prosecution, that can work in cases like this also. And not to belabor the point, so I can answer any questions that you may have, Mr. Chairman.
Any questions for Mr. Thompson? Yes, Senator Crum.
Yeah, Mr. Thompson, I'm just looking at the bill and the way it reads, it says if a person travels from one county to another county in Wyoming or from a county in Wyoming to another jurisdiction outside of Wyoming, but there's nothing in there about from another jurisdiction to a county in Wyoming. Is that something that should be added to the bill?
Mr. Thompson.
Yeah, Mr. Chairman, I think that would rest with this would apply to all 23 counties in the state of Wyoming. So I think we're taking care of the Wyoming citizens and Wyoming law enforcement. If another state has an issue with somebody absconding from Montana or Colorado, I think that's their issue to address in legislation.
Other questions for Mr. Thompson? Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Mr. Thompson, I think during our interim discussion also was about organized crime, and this was partially to address that issue. And what's your opinion? Do you still have the same opinion? It's going to help in that matter? Thank you, Mr. Chairman.
Mr. Thompson.
Yeah, Mr. Chairman, it surely won't hurt. I think if we look at the statutes that we have with conspiracy related things, there's some burden of proof that might be difficult to reach in full prosecution. So maybe this might better apply in those circumstances. I just think that it gives latitude to both law enforcement and the prosecution to correctly prosecute crimes based on the differences of each of them. Each crime is very different and the offender is different. And so this is not only gives that tool at the time to apprehend someone arguably on the run, but also an appropriate charging thereafter.
Anything else, committee? All right, thank you, Mr. Thompson. Any other public testimony? Co-chairman Washit, you were hiding in the back there. I didn't see you.
Good morning, Mr. Chairman, committee. I don't normally testify on committee bills before the Senate Judiciary Committee, but this one, I think there's still a piece that we need to work through. And I think we might avoid a conference committee at the end if maybe we get some discussion about it here. And that is when we talk about this organized retail theft, where these criminals come in and steal property right up to the felony threshold and then go to another state or perhaps even to another county. But certainly when they go to another state, I think it's true that we rarely extradite offenders for misdemeanor crimes. And so if the penalty for absconding is a misdemeanor because the criminal stopped right at that felony threshold, then when they get back across state lines, we still don't touch them. We still don't have a tool to deal with those offenders if absconding is not a felony. But as you recall from our committee testimony, we don't want someone who steals a candy bar in Casper and goes to Glen Rock to get charged with a felony. Now, I have perfect confidence in our prosecutors that nobody's going to charge this crime. As Mr. Thompson said, it's a tool that can or cannot be utilized as necessary. I think prosecutors are not going to tie up their workload trying to file a felony charge for a candy bar, and they're going to be able to use their discretion to decide whether or not it's appropriate to bring a felony absconding charge. And so that'd be my suggestion, is that maybe we look at a felony penalty for this crime. And I know it's problematic because we leave it to the prosecutors to make that judgment call when to charge the felony crime and when not to. But otherwise, I think we still have that gap. And remember, our discussion started on organized retail crime. And so if we're going to try and really deal with that issue of people coming across state lines, committing, a theft right up to the threshold, whether that threshold is where it is now or at the lower threshold, and then goes back across state lines, we're not going to touch those folks. So if this is the best we can do with the penalty matching the underlying crime, I can live with it, but I just ask the committee to at least discuss the possibility of how we might touch that gap.
Any questions for Co-Chairman Washut? Senator Kolb?
Yeah, thank you, Mr. Chairman. Well, under page 2B, 18, line 18, where the equals the highest offense you've committed, that in fact will, in some cases, be a felony, right? I mean, if I understand that right, the way it's worded, basically it allows them to match that level. So if you committed multiple offenses or whatever, and the court so deems it that you did, well, it would be a felony. Now, to the extradition idea, when you cross state lines, you're right. It's probably always going to hang out there, Representative. But what would be your suggestion then? We make it a felony and just a straight up felony, I guess, is my probably question after saying what I've said, Mr. Chairman.
Co-Chairman Washut.
Senator Kolb, I think that's at least one reasonable possibility, and then leave it to the prosecutor's discretion whether or not it's appropriate to charge that crime in the right circumstances. But you're right. There are circumstances where the underlying crime is going to be a felony. We've got that covered, but there's that gap where the underlying crime is a misdemeanor that stops just short of that felony threshold.
No. This is a Senate file. Okay. Any other testimony? Well, there's no one online, you said, for any of the bills. Okay. All right, then I will close public testimony. Committee, what is your pleasure?
Move the bill.
The Senate File 8 has been moved and seconded. Are there any amendments to this bill? Page 1. Any amendments to this bill? Page 2. Any amendments to this bill? Page 3. Any discussion on this bill? Senator Craig.
Thank you, Mr. Chairman. I was just going to address the co-chairman's request. I understand the request. I mean, this is what we struggled with over the interim, is how to do this so that we don't get into a problem where we have some constitutional vagueness built into the statute. And that would be my concern is, yes, we can give discretion, but I don't know what that discretion looks like. I mean, if we say it's a felony, I think we just run into and nothing else. We run into some issues. That's what we were trying to do, was match it to the underlying crime. Again, we had this discussion. My concern was, yes, it could happen for the lowest crime we can think of, candy bar or soda pop at the gas station, which is getting closer to a felony every day. But that's besides the point. Anyways, I don't know. I don't think we're going to solve it today. I mean, I'm willing to continue. We can all talk about it and help you when it comes your direction, if that's what needs to happen, or we can think about it and work it on the floor. But I don't have any good ideas for today. So I just didn't want you to think we're ignoring you. Happy to chat about it, but I don't have a good idea how to craft that language. And maybe the association, both of your associations could help us with that as well. So thank you, Mr. Co-Chairman.
Thank you,
Mr. Chairman.
thank you, Senator Craig. And one of the options could be that, similar to the theft statute in general, where it is, after so many offenses, it becomes a felony. And you could do something similar with this legislation as well. After so many offenses, it becomes a felony, because you're not necessarily trying to capture every single person that runs south of the border after stealing a piece of fruit or whatever it may be. But but if you've got a repeat offender, then I could see very much so that you want to extradite that offender, and you want to bring them back, and you want to have that option available. So I don't know, maybe that's something to kind of stew over. I would be interested in that idea. But I am in the same boat as Senator Craig. I'm still interested in figuring this out so that we can get it to work. So let's keep talking. All right. With that, will you please do a roll call vote on Senate File 8?
This is a roll call vote on Senate File 8. Senator Craigo?
Aye.
Senator Crum?
Aye.
Senator Hicks?
Senator Cole,
I thought it was Cole.
that was Hicks.
Oh.
Now the
wow.
whole record is
I mean,
messed up.
let me not vote for Senator Hicks.
We'll rescind that vote. Excused.
Senator Kolb? Chairman Olson?
Aye.
4 ayes, 1 excused.
Great. All right, the next bill for our consideration is Senate File 9, Fentanyl to Minors Enhanced Penalty. This bill, pretty straightforward. The name of the bill actually says it all. Creates an enhanced penalty for any distribution or delivery of fentanyl to minors. Any person who is over 18 and violates the statute by distributing to anyone under 13, guilty of at least 3 years separating, punishable by fine or imprisonment. And then we don't have that. It's whatever's in the statute existing. And any person who's at least 18 years of age who distributes fentanyl to a person under 18 is guilty of a felony, punishable by the fine authorized under the title in the bill, or up to twice that. I had this written down. Now I can't remember. Does anyone remember what the underlying statute was? Is it 10 years? 10 years and becomes 20 years if you distribute to a minor? We'd have to look it up, because I don't remember from the interim the gap. 10 years and becomes a 20-year? Let's look. Okay. So providing for an enhanced penalty for controlled substance offenses related to the distribution and delivery of fentanyl to minors over 18 and under 18 distribution. Regular sentence is actually up to 20 years and a fine of up to $25,000. So by doubling this penalty, we are saying that if you distribute to a minor and you're over 18, then it's 40 years. Or $50,000. So we're pretty aggressive. All right, that's what the bill does. Public testimony on this bill. Ms. Hackle, Mr. Thompson, And Ms. Hackle, if I misstated any of the statutes or penalties, please correct me. Mr. Thompson?
Thank you, Mr. Chairman. Alan Thompson with Wascop. I think that this was definitely in response to the data that we've had for the last couple of years about fentanyl overdoses and fentanyl deaths in the United States and in Wyoming. And I think you'll hear some, maybe some ideas that those numbers are decreasing or have decreased in the recent past. And I would just say that if we were doing the right thing, we would have been on front of this 3 years ago. And I don't think it's the time to pump the brakes on addressing the dangerousness of fentanyl and some of these other drugs, and especially with children thinking that they're getting a product that is not fentanyl, and the danger that fentanyl provides to the person selling it, the person using it, the person using something that they didn't know had fentanyl in it. The law enforcement investigation, or in this case, like especially with schools, teachers and staff in those schools coming across these items and the danger associated with it. So our organization does think that this is something that we would want to support and help become law in Wyoming.
Any questions for Mr. Thompson? I'm just curious, kind of similar to my questions before, data wise, I don't recall from the interim, but would like to have the data in front of me as we move through the session, what our fentanyl arrests look like in Wyoming, just in general. And then what if we, because it's currently illegal to distribute to a minor, obviously. I don't know if we separate that out in any of our data points, but that would be nice to know if we could know it. Mr. Thompson?
Yeah, Mr. Chairman, our organization has a little bit of that data on our arrests. So if somebody is a custodial arrest, we have some information on the type of drug that was involved in that. And I'm not sure that we have one data source to access to provide that, especially when it comes to ages. The only thing that I think we could look at is the enhancement, because it's a penalty enhancement. I don't think it changes you arrest for the same crime, but it's the penalty enhancement if you're selling to someone that's under the age of 18 or in a school or things like that. So I would just say that even if that issue doesn't exist, I think that if there was something that we would want to be more harsh about, it's protecting our children. So I think that the prevention aspect of this law, I think is important to consider also.
Yeah, I agree. I've already received that question of, I understand what you're trying to do, but how often is this actually occurring in Wyoming? And I want to be able to answer that as empirically as possible, but it doesn't sound like, I mean, whatever data you can get us would be helpful. Ms. Hackle?
Mr. Chairman, I know that in my office, I have an attorney whose job is solely prosecuting drug crimes. He's with the high-intensity drug trafficking area, which Cheyenne and Laramie County fall in that because we are the, conjunction of two major interstates. So he may have some data, but again, as Mr. Thompson said, we track the offenders, not necessarily the recipients of the drugs. But you mentioned this is an aggressive bill, and it needs to be. Fentanyl continues to be a problem. We're seizing not just us, but in the Rocky Mountain area, hundreds of thousands of fentanyl pills. And sometimes people, and sometimes it's not fentanyl, it's fake. But it's equally dangerous because who knows what it's made out of. So I will do my best to get you some data. But the Prosecutors Association definitely supports this bill and thanks you for bringing it forward.
Great, thank you. Appreciate that, volunteering to get us any data that you can.
Mr. Chairman?
Oh, sorry. Any questions for Ms. Hackle? Senator Crum?
Yeah, and I don't know who the best person to answer this is, Mr. Chairman, but my question would be, these dealers that are selling to minors, bad deal. But if they think they're selling, how many are out there thinking the guy selling on the street, think they're selling, I don't know, I don't even know nothing about drugs, but cocaine, and it's laced with fentanyl. does how do we handle that guy that thinks he's selling cocaine, but he's now selling, that he's unaware of cocaine and fentanyl laced together? How's that handled and that type of thing, I guess, is my question.
Ms. Hackle?
Mr. Chairman, Senator Crum, a lot depends upon what we find out from law enforcement. And often we don't know all of the component parts of a drug until after it's been tested and the person by then has been arrested and charged. So we often just go with a basic delivery charge or what the most obvious drug is. And if the defendant says, oh, wait, I was just distributing cocaine, or make some similarly, we just go with that. So I don't know how often we're seeing that. I know the crime lab is pretty overwhelmed with all the drug testing, but we do get those tests back. And so I will also say that if it is a major drug dealer, we often have those cases referred to the United States Attorney, and then they will prosecute them on the federal level, where they have, frankly, some stronger penalties, and they seem to put away their volume in terms of numbers of defendants doesn't equal ours, but the sentences that get imposed and the length of time that the defendants leave the community is noticeable. And so we try to take care of those kinds of serious cases that way. And it's an ongoing daily, battle, literally.
So committee, some data that was just shared with me on this fentanyl overdosing in the state of Wyoming by residents of Wyoming. In 2014, there were only 9 fentanyl-related deaths. But if you fast forward to 2023, there were 52 overdose deaths from fentanyl alone. So more than 5 times that in just about a decade's amount of time. So it is a pretty nasty drug. Any other questions for Ms. Hackle? Oh, all right. Thank you, Ms. Hackle.
Good afternoon, Mr. Chairman, members of the committee. I'm Nish Goikolea, Chief Policy Officer for the Wyoming Department of Education, and I'm here today speaking on behalf of Superintendent Degenfelder. As you know, she was here previously during the interim in full support of this bill and enhanced penalties for children and to protect our school safety. So we just would like to reiterate that on behalf of the superintendent. I'll stand for any questions.
Any questions for the superintendent's office? All right, thank you very much. We appreciate the partnership with Superintendent Degenfelder. You're next. Go ahead.
Mr. Chairman, members of the committee, my name is Clark Fairbanks. I'm with the Wyoming Youth Service Association, which is nonprofit youth service providers across the state providing prevention, intervention, and treatment. I stand in support of this bill. We see every day the impact of substance use and abuse by our children and youth and families. So this would be an additional tool and steps to provide increased penalties for those that prey on or exploit minors. It may help protect our children, and I think we're all committed to helping provide those protections to our children. So I'd stand for any questions. Thank you.
Any questions for Mr. Fairbanks? All right, thank you. We appreciate your testimony. Any other public testimony on this bill?
Mr. Chairman.
Yeah, back, Mr. Thompson, please.
Just real quickly, I looked at some data from 2024. About 3% of all custodial arrests in the state of Wyoming involved the other classification of drugs, not including alcohol, not including methamphetamine, and not including marijuana. So the danger, I guess we would call them the most dangerous set of drugs, would be that 3% component, and that fentanyl would fall within that 3% component. But if you compare that with the numbers that you have with overdose deaths jumping exponentially in that time, I think exemplifies just how dangerous the drug is.
Thank you. I appreciate that data. Anything else, committee? All right. With that, I will close public comment on Senate File 9. Committee, what is your pleasure? It has been moved and seconded. And are there any amendments to this bill? Page 1.
You did a good job in interim, Mr. Chairman. I don't think there's anything to do to it.
Any amendments on page 2? Page 3. All right, we've got a good bill. We feel good about it. All right, Pierre, will you please do a roll call vote on Senate File 9?
This is a roll call vote for Senate File 9. Senator Craigo.
Aye.
Senator Crum.
Aye.
Senator Hicks.
Excused.
Senator Kolb.
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
Senator Kolb can be taught.
Slow, but I can learn.
All right, the last bill for our consideration is Senate File 10, contracts for holding and treating mentally ill detainees. I will be honest, I have the least memory of this bill out of the 4 bills. But what it does is creates a new statute, 7-11-308, where the Department of Health may designate county detention facilities for the detention of mentally ill individuals. Facility, yeah, so facility down on page 2 in the definition shall include a county jail. And this is effective July 1st, 2026. And maybe we will start with our Department of Health. You might have to remind us a little bit about this bill. I have a vague recollection of it, but.
Good afternoon, Mr. Chairman, members of the committee. Stephen Johansson, Director for the Wyoming Department of Health. Joined to my right by Reagan Latham, who is the Senior Administrator of our Behavioral Health Division, has oversight of the Wyoming State Hospital, Life Resource Center, Community Mental Health and Substance Abuse Programming. Mr. Chairman, we're greatly offended that you don't remember every single issue at the Department of Health when you start session. But in all seriousness, happy to give our overview of the bill. You did a great job explaining it. This is a pretty simple Senate file, but as background, I'll remind the committee that this was an interim topic that was brought to you guys for essentially compensation reimbursement and capacity building for treatment of mentally ill detainees under Title VII. These are folks who are held either for competency evaluation or who are awaiting inpatient treatment for the state hospital, but being held at county jails and detention centers. The problem on our end is really threefold. It's the volume of orders that we get from courts for criminal defendants who may have or do have significant mental illness. We get approximately 40 orders a month for outpatient evaluations. We get about 10 orders a month for inpatient admission to the state hospital. And we have, second factor is limited capacity. We have a 104-bed facility at our campus in Evanston. About a quarter of that is dedicated to the Title VII criminal or forensic clientele. In addition, the third factor is we really do struggle at all of the Department of Health facilities, including the state hospital, with recruiting and retaining direct care, CNAs, nurses. That's been a big challenge, one that you all are hearing in other areas of your deliberations as a legislature for certain key and targeted state employees. So with those capacity limitations, this topic came up with your joint committee during the interim of what can be done. And in partnership with Mr. Thompson, WASCOP, and many of the sheriffs, we developed a work group to try to build off of a few initiatives that we already had going between law enforcement and the Department of Health. And I'll name a couple of those. Over the past 2 years, in partnership with a few communities, some Title VII diversion programs had started for very low-level misdemeanor offendants to where they could be essentially diverted to community treatment in lieu of wait list to inpatient treatment at the state hospital. And that's been marginally successful in Laramie County, starting last year. Natrona County has also, in our original county in Campbell County, was the original pilot location. And I think those are very good directions to move. In addition, about a year and a half ago, we executed a memorandum of understanding and a contract between a treatment provider, the Department of Health, and Laramie County Detention Center, one of our largest in the state, to try to offer and reimburse for telepsychiatry within the walls of that jail. Again, for certain criminal detainees who are very, very, very sick with mental illness and are extremely violent, dangerous to themselves, hurting staff. And over the last year, as you heard during the interim from our Laramie County Detention Center staff, has been largely successful getting more treatment into that facility in partnership with the Department of Health, but really executed on the ground by the folks in law enforcement. This bill, which is permissive to the Department of Health, allows us to take that type of programming to the next level. So essentially what it allows us to do is a couple of things. One is to reimburse county detention centers for what you'll see in the language here, security of those detainees. That's essentially the holding of Title VII detainees who are awaiting admission for services by the state hospital. The second is you'll see examination and treatment. Now, we pretty much have the examinations covered. That we do that through forensic evaluator contracts, largely on an outpatient basis. But the treatment is a key here. We know that through a couple of interested counties and detention centers, we've executed an agreement with Laramie County Detention Center. We have an MOU in the works with Natrona County Detention Center for us to partner and the Department of Health to help facilitate active treatment going on in the jails. Now, that does not have to happen for every single jail. We know that there are counties, there are detention centers that maybe do not want to get into this line of work in mental health service, or potentially don't have the capacity to do that. But for those who do, we think it could be a very big stabilizer and decompressor of the overall system. And that system that I'm referring to is the wait list that is extremely painful for county attorneys, courts, detention centers, because on Title VII, our wait list right now for inpatient admission is between 3 and 6 months, really moving more towards the 6-month wait list. That's not as bad as the 5 to 6 years in California for their forensic wait list, but it's certainly not acceptable to us, to the state. But it really does come down to that black and white dollars and cents capacity issue with the volume of orders and the capacity that we have at the state hospital. Mr. Chairman, this, again, you'll see this bill is permissive. We believe it's a good bill and can help facilitate this continued partnership between the Department of Health, state hospital, and our county detention centers. And the last thing I'll refresh your memory on, Mr. Chairman and members of the committee, during the committee debate on this bill, before it ultimately passed to what you see now, there was a discussion about the appropriation that was in here, which was ultimately stripped out by the committee in favor of a letter to the Appropriations Committee to consider and potentially support that funding. The Joint Appropriations Committee did support that funding in the markup of the Department of Health budget, and it will be in that budget as, I believe, a footnote or a Section 300 from letters that they received that you will see on both floors of the legislature. With that, Mr. Chairman, Reagan and I are here to answer any questions you might have. But again, we believe this is a good bill. We appreciate the partnership with WASCOP, the sheriffs, the detention centers, and the folks that are involved trying to make this system better.
Thank you. Appreciate the refresher and the explanation of the bill. Any questions for the Department of Health Committee? All right. Really do appreciate it. Thank you. Mr. Thompson. We should just create you a permanent chair up there.
Thank you, Mr. Chairman. Alan Thompson with WASCOP. I would just like to say that from a mental health perspective in law enforcement in Wyoming, this is the single most important bill for our sheriffs this session. And it's not because they want to be in the mental health world, but they are. And this is the best conversation that we've had in a long time through the kind of the informal working group with the Department of Health and trying to address the needs of 23 different jails in the state of Wyoming, varying in bed size from 7 to several hundred. And it's just amazing to me that such a simplistic concept and an appropriation that our appropriations committee has provided can make such a positive impact in moving forward with. We're very hopeful that this is going to help both those large facilities and the small facilities alike. So I would just ask for your continued support here and on the floor, and in any way possible that we can help with this. I will be happy to pick up the phone and call our sheriffs to reach out to members and explain any questions that they might have with this. But we're very much looking forward to working with the Department of Health should this bill pass this session.
Senator Craigo.
Thank you, Mr. Chairman. Ms. Thompson, thanks for being here. Just a quick question. Do you think there will also be coordination in between individual jails? For example, if we have one of the smaller counties that can't provide the services, but their neighboring county can, I'm thinking in particular Northeast Wyoming, right? Do you think there will also be coordination or availability of coordination there so that we could use all available resources rather than loading people up and hauling them all the way to Evanston?
Mr. Thompson.
Yeah, Mr. Chairman, I don't know. That's definitely possible. And that's usually going to be borne by the relationship between those individual sheriffs and needs not just with this, but other agreements with, things like dispatch services and coverage and all those sorts of things. But I think what is very realistic is that if we have 50 people in this program and 30 of them happen to be in the largest jails in the state that are offering treatment, they've got to step in the right direction rather than being warehoused. And so if they do make it to the state hospital, their bed stay there should be less. They might be restored in the county jail and not ever have to go to the state hospital. And that will free up the bed space for the person in the 7-bed jail that's trying to get in there. And the wait last year was 9 months. Now, maybe it's 6 months, maybe it's 3 months. So I would just answer your question by saying, yeah, we're hopeful that could happen. But if it doesn't, this still could impact that weight substantially.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Well, I guess the first question is, has the Board of County Commissioners, we don't have anybody here today, so I assume it's not a big deal, but they're going to be the ones agreeing to these contractual agreements vis-a-vis the sheriffs in their counties. So I guess I just wondered, any conversations with them, bringing them into this conversation about just what this cooperative agreement could look like, MOU between counties. I don't know, has anybody put any thought into that? I mean, actually having a system like this work, and then the reality of saying, say Sweetwater has X amount of beds and Carbon County doesn't have any, or whatever be the case. Any thought about having some sort of cooperative agreement ability between counties that maybe the state might have to facilitate, just in a broad way? Once we get this thing going, what's going to happen? Because we have a problem with the mental illness situation currently, right? You offload them over here because nobody has any facilities over there, and typically it might be maybe a facility in Casper that we have to transfer to, but this will be kind of the same thing, keeping them in the jail. So any thoughts with your group on what they may or may not think about this? Any discussion?
Mm-hmm.
Thank you, Mr. Chairman.
Mr. Thompson.
Yeah, Mr. Chairman, I personally haven't dove into that county commission conversation. Some counties, it would appear to me, might engage in these contracts between the sheriff and the Department of Health. Obviously, that funding has to go to the county general fund. So there's that component of commissioners being part of that conversation, if not part of the contract. And then, I just feel like as the executive director of WASCOP, that's a sheriff and commission responsibility, but we will be happy to facilitate any of those discussions or education components as we move forward. This bill just allows it to happen. So there's a lot of build out that still needs to occur should this become law in what those agreements look like and rules and things like that. And we would be happy to be part of all that discussion going forward.
It's just kind of dovetailing off of Senator Craigo's question. I was wondering something similar. I mean, I'm really curious. In the larger counties, I see this legislation being very effective with respect to treatment. But in our more rural counties, there's no, they don't employ the personnel to handle this. And there's not the same amount of community resources available to provide the treatment. So, do you envision a next step after this, or are we really just solving problems in big counties like mine? So I appreciate it, but I'm also thinking about the smaller counties as well.
Yeah, Mr. Chairman, I don't think our small jail sheriffs think that this is solving a problem in a big county only. I think it's giving them an opportunity to have the funding to bring in extra personnel to cover those extremely time-consuming inmates that they might have once every 3 years. So that in and of itself is better than where we're at right now today. And then the hope that the future availability of bed dates, it's my understanding some of the data we were looking at this summer, that wait time's gone down a little bit, kind of organically. So this should help all of that. And I don't see it as it's not the answer to everything. This is one more cog in the wheel of mental health, and this is just applicable to those Title VII holds. You know, this isn't a Title 25. This isn't various other things, and we're working on those aspects too. So I do think if, like I said, that this has a propensity to help 23 different sheriffs in varying ways based on the needs of those sheriffs. And, you know, if they want to have agreements with other counties to do things, that's fine and dandy. But I would also just let the committee know that as we know, the liability that attaches to inmates of mental health degrees like this and the time consuming part of it is very difficult to convince another sheriff to take your inmate that you know is going to be extremely time consuming, difficult, and a liability. So that's a hard lift right there.
Senator Kolb.
Yeah, thank you, Mr. Chairman. And getting back to page 2, the line 15, and it says other facilities designated by the court. I guess my question is do you believe that could be problematic by the courts deciding in a county that say is overloaded? Say they don't have the court, you know, can say whatever they want really. And they can say, I designate this place to be the place you're going to get the treatment at. And the consequence would be is that said facility would then be overrun with folks being detained there for this purpose. And I am concerned, or maybe that there's a potential there that the courts can do what they want to do and designate it, and then by so doing would then obligate that facility to take those folks. And I'm concerned that may come up, but just, I think food for thought.
Okay.
Sometimes when we do things like this, the flip side can happen to us, unless there's smarter folks here who could answer that. But thank you, Mr. Chairman.
Senator Craig.
Yeah, Mr. Chairman, I was just going to chime in on that question. So that's already current law. And so I don't believe that's an issue as of today. I mean, that particular language you're citing is the current law.
Senator Kolb.
Yeah, Mr. Chairman, I understand that. But Lindsay, the next question is why wouldn't they do it in any way if they designated it? I guess the facilities weren't proper. But I was just concerned that the courts would then take and run with it and go, okay, you can take these folks because we don't have to send them to Evanston to be evaluated. We'll do it here. You do it because I said so because I'm the court. That was my concern. If my more learned, licensed practitioners of law, you know, that think something different, I just was throwing that out there as could that happen? Respectfully, thank you.
Any comments, Mr. Thompson? Kind of outside your realm.
Mr. Chairman, just to add a little color, I guess, the court orders exist ordering people to certain facilities all the time, and that's not always met because of availability of bed space and so forth, which is kind of why we're having this discussion here. So that exists in various other statutes, and those orders aren't always obeyed based on availability. So I don't know. It opens a can of worms, Mr. Chairman and Senator Kolb.
Anything else for Mr. Thompson? No? All right, thank you. Any other testimony on this bill? Welcome to Judiciary.
Mr. Chairman, Bill Winnie. Glad to be here. Across my career, I spent 5 years, a little bit more than 5 years in command. One of the two ships was large enough to be a medium-sized municipality. I rarely, but occasionally had to deal with the kind of subject you're dealing with today. And in my observation, once you get the medical determination, that responsibility comes back ultimately to the state legislature to provide links for training for the rare occasion on those smaller municipalities, and a link for the sheriffs to talk to each other and put the guy wherever is appropriate medically. But it's a medical issue and you have to deal with it that way. If you try and deal with it as a pure law enforcement type issue, you end up at the wrong place. And so our smaller communities, as you've heard, sometimes apparently struggle with that. Subject to your questions, thank you.
Any questions for Mr. Winnie? All right, we appreciate it. Any other public testimony? Nope, I will close public testimony on Senate File 10. Committee, what is your pleasure?
Move the bill.
It has been moved
Second.
and seconded. Any amendments to page 1 or 2 of this bill? Or 3? I'll even let you amend 3 if you want to. No? Okay. Oh, wait, yes, Senator Craigo.
Thank you, Mr. Chairman. So conceptual amendment, I don't know, have the exact language, but I just was thinking about it while we were having the discussion about coordination between the counties, coordination between the department and the counties, and maybe it wouldn't be a bad idea to have within a year of the enactment, get a report back from the Department of Health to Joint Judiciary on the numbers, essentially the people that are using the program, how it worked between the counties, how each county used it, et cetera.
So just a friendly amendment to that. A year is good. We traditionally use October 1 as the report.
It's fine.
Timeline, if that works for you.
That's friendly. And so that, I guess we would, between the, I don't know if we're gonna have a whole lot of contracts.
Probably
Mr.
not in the
Chairman,
first.
between July 1st and October, so we could go to the following October of 2027.
Sounds good. I like it. That's a motion
Second.
and a second by Senator Crum. Any discussion on this? Any further discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment does pass. Any other amendments? Any discussion on this bill? Pierre, will you do a roll call vote on Senate File 10?
This is a roll call vote for Senate File 10. Senator Craigo,
Aye.
Senator Crum, Senator Hicks,
Excused.
Senator Cole,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right, that's all we have for today. We are adjourned.